Welcome back to another episode of the Politics with Paul podcast with your host, Paul Rader. Today, we're going to talk about amendments to the U.S. Constitution. We've had 27 of them over the course of our more than 230 years under the U.S. Constitution. An extraordinarily difficult document to amend, but at some point, we'll probably see a 28th amendment to it. So, what could it be, and when could we see it? Well, that's what we're going to talk about today. So, obviously, we should first start with the process of amending the US Constitution. So, for an amendment to be become part of the Constitution, it first has to be proposed to Congress. Congress has to approve it, and then it has to be passed on to the states and be fully ratified after enough states pass it there. So, two methods of proposal. One is two-thirds of the US House and US Senate approve the amendment to become ratified at the next step, or a national convention is called by Congress at the request of two-thirds of the state legislatures. And then, if it passes that point, the two methods of ratification are three-quarters of the state legislatures, which is 38 out of 50 states, or special conventions called in three-quarters of the states approve the amendment for ratification. So, a few quick ratification stats for you. The average number of years per amendment that actually gets ratified, there's been about 12,000 amendments that have been posed at some point in front of Congress. Very, very few of them even sniff the ratification procedure. In fact, we've only had 33 that have been passed by Congress, but only 27 of them have been fully ratified. So there's 6 that have at least gotten to the ratification stage, but have not actually completed it. Average number of years per amendment. So 1789 was the year of full ratification of the U.S. Constitution. Prior to that, we had the Articles of Confederation. So 235 years divided by 27 amendments, we average about one amendment being ratified every 8.7 years. But the first 10 amendments, which are the Bill of Rights, those were all ratified a little over 2 years after the Constitution was ratified. So that was in 1791. So if we consider that statistic, we've seen 17 amendments over the course of about 233 years. So 233 divided by 17, average one amendment being ratified every 13.7 years. Now, it's sometimes come in spurts where we've had a bunch of amendments in a small period of time, and then later on, more get ratified much further down the line. Not always, but in some cases, we've had them bunched up. So, how long does a state's passage of an amendment generally last, or rather, the time between an amendment getting passed by Congress and then getting ratified by the states? Well, when Congress passes it and ratification happens, those are two different things. So the shortest time frame has been about a little over 3 months for the 26th Amendment from passage to ratification, which lowered the voting age to 18 years old. We'll mention that specific amendment a couple times shortly, but the longest time frame, on the other hand, was 43 months, give or take a few days, which was the 16th Amendment, which allowed for an income tax, another one that will be mentioned shortly. But some amendments that have been proposed but don't really go anywhere, there's been some rather curious ones. We have a 0.003% rate of ratification for these amendments, and ones that have not even gotten close to that include abolishing the U.S. Senate, which was proposed in 1876, so that would have made Congress unicameral. We have a U.S. House and a U.S. Senate, so then we would have just had the U.S. House if that actually got ratified. We had another one that would have renamed the U.S. the United States of the Earth in 1893. Interesting one. And abolishing the U.S. Army and Navy in the same year, 1893. That was one that was proposed. And then there was one that would have made divorce illegal in 1914. So some of the more curious instances. But again, those really didn't actually go anywhere. Now, before we get to what could be the 28th Amendment to the Constitution, we should talk about the amendments that have come before. And you can think of them in several major groupings. They're not necessarily, for lack of a better term, objective, where they're groups that are recognized by a wide swath of people. The Bill of Rights is one that everybody recognizes, but there's some other ones that I've sort of made up on my own. Some people may consider them a similar grouping, but just to make it easier for thinking about what kinds of amendments have come up in the past. A couple of them are commonly categorized groups, others not necessarily agreed upon, and a couple of these amendments that according to this system that I've just made up, they're ungrouped, which was the 11th Amendment, which dealt with lawsuits between states, and then the 27th Amendment, which dealt with congressional compensation. So the groupings that I've some partially just devised on my own and some that are recognized by others. The Bill of Rights, first 10 amendments, so those are things like the freedom of speech, freedom of religion, press, assembly, and petition, the five freedoms that are in the First Amendment, Second Amendment, right to bear arms, fourth, protections against illegal searches and seizures, all those sorts of things, cruel and unusual punishment, protection against that in the Eighth Amendment. So a bunch of those kinds of things that we kind of just assume we take for granted were in the Bill of Rights. And the fact that that Bill of Rights was not originally part of the Constitution was one of the big points of opposition for the anti-federalists, the people who opposed scrapping the Articles of Confederation and replacing it with the U.S. Constitution. But a couple of years after the Constitution, Federalists, or people who supported the Constitution, promised that this Bill of Rights would get added later on, and it did in 1791. But that was a big point of contention in the debate over the ratification of the U.S. Constitution. And then the other group that's generally recognized as a group by most other people is you have the Reconstruction era amendments. And Reconstruction era refers to the post-Civil War, specifically years. So late 1860s, 1870s. The Reconstruction era amendments were the 13th, 14th, and 15th Amendments. Those mostly addressed racial inequality. So 13th Amendment, slavery, obviously a long time coming, should have been done well beforehand, but it wasn't until right around the very end of the Civil War that slavery was abolished outright. 15th Amendment granted the right to vote for all males, regardless of race. Women's right to vote wasn't until several amendments later. But the 14th Amendment, while it's mostly known for the Equal Protection Clause, it's got kind of a wide scope. It also deals with Civil War debts and preventing people who have been uh, convicted of insurrection and rebellion against the government from being able to hold office as president, vice president, U.S. Senate, U.S. House, or even other offices at the state and local level, unless Congress, two-thirds of each chamber of Congress, decide to override that its ability. But mostly known for the Equal Protection Clause. And then you have the Progressive Era Amendments, 16th, 17th, 18th, and 19th Amendments. That's some people would probably recognize that as a group of amendments too. So 16th Amendment instituted an income tax. 17th Amendment changed the choosing of U.S. senators so that instead of being appointed by state legislatures, which is how it originally was done, they are now directly elected like U.S. House or president it is by voters. Now it's a direct election as opposed to the state legislatures choosing their state's U.S. senators. 18th Amendment prohibited alcohol, consumption of alcohol, sale of alcohol, distribution of alcohol, and the 19th Amendment instituted the women's right to vote. So the Progressive Era was marked by widespread social and political activism in the early 1900s, particularly against big business. Progressives of then and progressives of today, they do have some similarities. Their ethos is somewhat similar, but some of the issues are a little bit different. For example, back then, until 1920, with the ratification of the 19th Amendment, where women were granted the right to vote. Some states did allow women to vote, but not all of them. So that was an issue back in that day. Obviously, now women can't vote, and they actually tend to vote at much higher, well, not necessarily much higher rates, but they tend to vote at higher rates than men do now. And then you've got the two alcohol related amendments, 18th being both part of this group and the progressive era group. A few of these amendments could be considered part of a couple of groups. And then the 21st Amendment repealed prohibition. And it's the only time we've actually had one amendment repeal another amendment. And you've got the presidential related ones. These are more non consecutive, so they weren't in rapid succession. The 20th, 22nd, and 25th Amendments. The 20th is most known for changing what they call the lame duck period, federal government, which is that time frame between when the next batch of federal elected officials is elected and when the previous ones actually end their term. So now that's shortened, and terms for federal officials end in January. 22nd Amendment then changes it or codifies it so that presidents can only be elected twice, or they could actually serve up to 10 years if they take over past the halfway point of a previous president's term. So 4 years is a full presidential term. Halfway would be 2, and then they can still get elected twice. So it can be up to 10 years that a president can actually serve. And then the 25th Amendment, which clarified procedures for succession to the presidency if the president is incapacitated in some way. They resign, they impeach, they pass away in some way. The 25th Amendment clarified these procedures. And part of what really was the impetus for that was the assassination of JFK. And finally, we have the voting related group of amendments. So we have, again, the 15th Amendment, voting rights regardless of race. 19th, regardless of gender you are. 26th Amendment lowered the voting age to 18 years old. But we also had the 23rd Amendment, which granted electoral votes to the DC area as if they were a state. And then the 24th Amendment, which abolished poll taxes. And poll taxes were a method of particularly southern states to try to suppress the black vote. So what they did was you tried to vote, you had to pay tax in order to vote. And you might think that, well, doesn't this also apply to poor white voters? Well, a way that southern states got around that was, for example, grandfather clauses, and where if their grandfather was allowed to vote, then they didn't have to pay these poll taxes. So very insidious ways that black voters were deprived of the right to vote. But technically, they still had it. In name, they had the right to vote. They had suffrage, but in reality, they couldn't actually do it. And if they weren't, even if they weren't poor voters, there were still all sorts of voter intimidation tactics that were used against them as well. So before we actually get into the potential 28th Amendment that we may see in the future, let's talk about how we can evaluate the likelihood of the next amendment to the U.S. Constitution. There's no clear-cut way of this is how you need to hit these particular points, but these are things to consider if if, for example, if you're supporting one of these amendments and you're actually trying to get it passed. So one is the subject being addressed a particularly controversial one in some way, especially if it's got a partisan or ideological charge to it, if it has a discernible bent, not even necessarily in terms of support. Maybe support is across the aisle, but there's still one party that's still particularly opposed to that amendment. You're unlikely to get enough states to back it, especially in today's polarized climate. So, one thing to consider there. Number two is a little bit obvious, but what are the exact details? So, get more specific with that. How specific or general does the amendment get? So, broadness of the topic must be accounted for. 14th Amendment is much broader in scope because it's got a wider scope than, say, the Second Amendment, which deals specifically with firearms. 14th Amendment deals with the Equal Protection Clause, but also Civil War debts and insurrection and a couple of other things I can't remember off the top of my head. Also, the length of the amendment. 11 amendments have at least two sections. So they go section 1, blah, 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 section 2, blah, blah, blah. Some amendments are incredibly short. None of them are particularly long, but some of them are very short, and others are a little bit wordier. So, length of the amendment must be considered, and similarly, wording of the amendments. So, the phrasing matters, especially when it comes to legalese. Lawyers find all sorts of ways to try to interpret the meaning of law to suit their whims. That's what lawyers do. So, you need to account for exactly how you phrase these amendments because that could make or break whether they A, get passed by Congress, but B, certainly whether they get ratified by the states. And then the usage of numbers, some, not all, but some of these amendments deal with specific numbers that refer to things such as the proportion of Congress that needs to support something, or the number of officials that are affected, age, dates that these amendments take effect. 3, what are the previous policies and precedents regarding the amendment, whether it's federal or state level? Is it something the US Constitution or other federal law has specifically addressed before? Does it say anything regarding this particular subject area that the amendment would be addressing? Has a constitutional amendment been tried for it in the past? There's about 12,000 of them that have been tried at some point. Have any of them referred to what exactly the subject area your amendment is about? Have any of those amendments addressed that subject area? Number 4, is there a particularly strong movement at the state or local level regarding what that amendment would address? So the timing of these amendments is also very critical, as the what we call the zeitgeist can make it easier or even just possible at all to ratify these amendments. And by zeitgeist, that's basically the spirit of the times. As times change, zeitgeist changes a lot. You got to account for those kinds of things when you have future amendments that you're considering as well, like expanding suffrage to black voters or voters of any race, to women, to 18-year-olds, that sort of thing. And one of these time frames that you can really look at as a perfect example is the progressive era, like the income tax and the direct election of US senators. The progressive era made those was perfect timing for those kinds of amendments to be not only passed by Congress but then ratified by the states. And then lastly, would it be a, for lack of a better term, quote unquote, better approach for each individual state to amend their respective state constitutions in this manner? And we'll obviously talk a little bit about that with more specific examples. But is it even something that's in the purview of the states that the states could even address? Because there might be some things where the states can address it, but in other times they can't. So now, finally, we'll go into some of the potential candidates for the 28th Amendment. Now, there's probably think of a whole slew of candidates that might make for that have a decent chance of becoming the next amendment. But I've just chosen 4 in particular that I think might make sense as a next amendment. Now, I'm not saying that there's something I support or I don't support. It's just based on the various factors that I included about evaluating the likelihood of these amendments. These seem to be more likely than most other ones to become the next amendment, whether that be the 28th one or another one down the line. So the first one to talk about is the Equal Rights Amendment. And this is a very unique situation because of the uncertainty surrounding whether ratification by some states previously still counts for this amendment. This is one of those 6 amendments I mentioned that were passed by Congress but did not quite get the number of states it needed. So, a brief history of the ERA is in 1972, Congress approved the ERA. The original deadline to be ratified was for 7 years. It got extended until 1982, by which point only 35 states had ratified it by that deadline. 38 were needed. Those three states may have now ratified it. The state of Nevada in 2017, Illinois in 2018, and Virginia in 2020 just ratified it in those years and argued in court that the archivist of the U.S. could publish and certify those amendments or their Equal Rights Amendment as part of the Constitution. So they took court, U.S. District Court for D.C. dismissed the case, saying the states lacked standing to invoke the court's jurisdiction, and then that was upheld by the U.S. Court of Appeals for the D.C. Circuit. So there's still a lot of debates as to whether Congress can remove that original ratification deadline and whether the 35 ratifications before the deadline still stand. So these were ratifications made in the mid to late 70s, even early 80s. That, in a lot of cases, vastly different governments than what they are now in terms of partisan and ideological leaning and just the kinds of people that represented them. So, do those ratifications still stand? That's the subject of a lot of debate, but we'll see where those go. So let's go back to the considerations, those 5 considerations I brought up for the ERA. So, is it controversial? Number one, and it's the fact that there are legal arguments regarding it as kind of clues you in as to whether or not it's controversial. The biggest point of contention is whether the ERA allows for abortion, not only for abortion, but basically abortion up until fetal viability or even up until birth. So we'll talk about the details of the ERA. It's a very short. It's got 3 sections, but they're all very short. So section 1 says equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. Section 2, the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Section 3, this amendment shall take effect 2 years after the date of ratification. Now, you'll notice that abortion was not specifically mentioned in the amendment, but going back to how specific or general an amendment is, there's some debates as to whether or not abortion is in the purview of the ERA. And the possibility of abortion was a prominent part of the campaign against the ERA, particularly by Phyllis Schlafly, who was the public face of the campaign against the ERA. And now, with transgender policies also becoming more and more salient, now those might also be considered part of the ERA's purview. So again, it's not about whether or not it's a good or bad amendment. That's for you to decide. But those kinds of controversies have been very effective at stopping it from becoming fully ratified. So, regarding previous policies, obviously the states have all had their various. They've addressed these kinds of gender issues in various ways, particularly with abortion, and whether those previous ratifications still stand is debated, and whether they still stand has huge ramifications for the possibilities for the ERA to be passed, or to be completely ratified by the states. If those don't stand, then there's a long road for the ERA to have to go back and get uh, passed by all those, or not passed by Congress again, and then to become ratified by all those states again. So grassroots movements, again, the 4th consideration, there's strong grassroots movements both for and against it. There were back in the 70s and 80s, and if the ERA picks up steam again, you can guarantee that those grassroots movements on both sides of the aisle are going to pick back up for it again. And should it be state level for the last consideration? It's pretty hard to say. It's because of all those reasons we talked about before, where how much do those ratifications from previous states still stand, and is it what exactly is in the purview of the ERA? That's still debated. So it's really hard to say for sure whether the better quote unquote approach would be to have the states do add their own ERAs to their state constitutions. So, second of four potential amendments we'll talk about is term and or maximum age limits for Congress. So the first numbered episode of this podcast, technically episode 2 due to my intro episode that described the podcast, centered on these age limits for Congress specifically. So considerations, is it controversial? Doesn't seem to be the case, but that doesn't mean it can't be in the future. Age limits probably be more controversial than term limits, and as always, I'm not saying that we should or shouldn't have them. That's for you to decide. So the details of such an amendment, should it address both term and maximum age limits, or should it just focus on term limits, or should it just focus on age limits? If we focused on term limits, how many terms would term limits allow for? Would they be consecutive or cumulative? So consecutive meaning, let's say we have 4 terms be the term limit. So you can serve 4 back to back to back to back terms. You can then you'd have to sit out for a term and then you can run for it again. Cumulative, on the other hand, if it was those 4 terms, you'd serve those 4 terms in the U.S. House, and then that's it. You can't serve in the U.S. House ever again. So, would it be a consecutive or cumulative term limit? Is it a different term limit for the U.S. House and the U.S. Senate? You have to account for the stark differences in the term lengths of these offices. U.S. House, 2-year terms. U.S. Senate, 6-year terms. Previous policies, federal and state level, both have some examples of this. So it has some support from federal officials, but not a whole lot of actual movement, save for nonprofits like U.S. term limits. And at least for state legislatures, 16 states have term limits for their state legislators. North Dakota, I believe, was the one that just became the most recent one. And then you have the grassroots movements, or are there grassroots movements? So again, U.S. term limits is probably the most visible nonprofit. There's probably some other groups that are involved in it as well. And then is this something that should it be addressed by states in their state constitutions? So North Dakota in 2022 just passed a state constitutional amendment that limits members of Congress to being 81 years old. Probably start to see some more states at least try to pass a constitutional amendment similar to that, whether it's 81 years old or maybe something like 75. We'll have to see. But right now, North Dakota is the only one that's taken that far of a step to actually address the age of their members of Congress. So, third potential amendment, sort of similar to Congress, is term limits for the U.S. Supreme Court, or SCOTUS for short. So currently, SCOTUS justices have lifetime terms, though they can be impeached or retire. The idea back when the framers of the Constitution were making it, argued especially vociferously by Alexander Hamilton. Yes, that Alexander Hamilton, in I forget which Federalist paper it is, but the idea is it would shield justices from political pressures if they had lifetime terms. But that view has been called into question in years since, especially in more recent decades, as Supreme Court confirmations have become much more bitter partisan and ideological battles. So now, should they actually have terms, or not just term limits, but actual term lengths? So, controversy, probably going to be more so than for Congress, given that SCOTUS was explicitly designed to be a lifetime appointment. And then you also got all into question about the separation of powers and checks and balances being how power is divided between the executive branch, which is president and cabinet, legislative branch being Congress, and the judicial branch being the courts. Does it upset that balance in some way? Does it tip the scales of checks and balances towards the executive or legislative or both branches in comparison to the judicial branch? That's up for debate. Details be how long do we make these terms, and should they be staggered for each of the 9 justices, or would it be we have 3 justices that are appointed again at the same time, or is it just one every 2 years or every 1 year? So previous policies Mostly you see them at the state level, where state level governments have term lengths for their justices. They have also mandatory age limits, but they don't have term limits. Term lengths, but not term limits. So their term is for a certain period of time for a lot of these states. And then there's a bunch of them that also have mandatory age limits. So they can serve up until they're 70, 75, however many years old a state has it set for. But at the federal level, Democrat Ro Khanna of California introduced a bill back a few years ago for 18-year terms for SCOTUS justices, and one would be appointed every 2 years. But the bill didn't really go anywhere. It sat in one of the judicial subcommittees, so that didn't really go anywhere. Would a bill like that pick up more steam again, or would it have to be a constitutional amendment? Grassroots movements, the most visible group is probably the nonprofit Fix the Court, which seeks those 18-year terms or those 18-year terms, and each justice being appointed, or one justice being appointed every 2 years. And lastly, should it be a state level thing? This wouldn't be even in the purview of the states, because those state governments don't actually have any jurisdiction over SCOTUS. So this is probably going to have to be a constitutional amendment, if not a congressional bill. But again, with that congressional bill, there may be that issue of the separation of powers and checks and balances. So it may have to become a U.S. constitutional amendment for that to actually become a reality. And then lastly, we'll talk about campaign finance reform, specifically independent expenditures. So these independent expenditures, also called super PACs, they can raise and spend unlimited amounts of money in support of or in opposition to a candidate or a ballot measure, as long as they do not coordinate with those campaigns. One of my former adjunct professors calls it orange jumpsuit rule. If you break it, you will be going to jail and you will be doing some hard time, or at least for a long time. So it's a big no-no for these campaigns, these independent expenditures, to coordinate with the main campaign. So a super PAC for Donald Trump can't coordinate with Donald Trump's campaign. A super PAC for Kamala Harris can't coordinate with Kamala Harris's campaign. If they do, there will be some serious legal repercussions for them. So controversy, hard to say with complete accuracy, but public opinion seems to be pretty decidedly against independent expenditures. However, these committees that engage in independent expenditures are certainly going to be against it, and they're going to spend exorbitant amounts of money to try to stop this amendment dead in its tracks, stop Congress from even passing this amendment, so it can't even have a chance at being ratified by the states. And then elected officials are often against these super PACs too, because it's an easy way to get political brownie points. Until these super PACs start benefiting them, then it's not such a big deal anymore. So the public opinion is probably not going to be too much of an issue. It's whether elected officials, are going to actually take the step of banning these independent expenditures. So, details: would super PACs be eliminated outright? Would the amount of contributions and spending simply be capped? What would that cap be? So, several different moving parts to consider for that. Previous policies. So, here you've got several court cases that you've got to contend with, the rulings in these court cases. So, all the way back in 1886, we had the Santa Clara County versus Southern Pacific Railroad Company case, which recognized corporations as people with all the rights that entailed. And then, particularly important and relevant for independent expenditures, Citizens United versus Federal Election Commission in 2010. The ruling there protected corporations from certain government regulations, and that's what really paved the way for these independent expenditures. So, as for grassroots movements, I couldn't find a specific nonprofit that pushed for a constitutional amendment to ban independent expenditures, but there's undoubtedly groups that are going to try to make that a reality, given the public outcry against the Citizens United ruling. And then lastly, should it be a state level issue, where do they put it in the state constitutions? given that these federal courts have ruled that these independent expenditures are okay, it's probably going to be considered unconstitutional for a state to try to ban independent expenditures. So it's going to have to be a U.S. constitutional amendment, most likely. So that does it for the talk about amendments. So going to end it off with the random question of the day. So the random question of the day is, what is the superior font type for electronic documents? Now, I've become an Arial guy over the years. Calibri is also okay too. I used to be much more of a Times New Roman guy. Nothing against that, but I've taken to Arial and Calibri a lot more. Just don't do Comic Sans because you cannot possibly be taken seriously if you use Comic Sans. And then yeah, wingdings are kind of funny, but nobody can read them. So I mean, don't don't answer that either. But I mean, I guess you can, but don't use Comic Sans. That's just you can't be taken seriously if you do that. But anyways, that's gonna do it for this episode. Once again, as always, thank you so much for tuning in. Please like, comment, share, subscribe, share with all your friends, and so that they can hear me yammer on about all sorts of political topics. Because I I like to think I'm really good at that at least. But maybe I'm not as good at that as I think I am. But anyways, thank you so much again for listening. You can follow me on Facebook at Paul Rader, author and speaker. Also on LinkedIn. I write on medium.com about political science topics, always from a nonpartisan lens, of course. And then my website, paulrader.org. And as always, catch my podcast every week. And that's going to do it for today. So until next time, take care.